So, we welcome to the Business Hub this morning top London lawyer Deborah Jeff of Seddons Solicitors, who's head of the family department there. Good morning to you.
Good morning.
Thanks very much for joining us on the show, Deborah. How is life at the moment? Are you busy?
It's very busy for family lawyers at the moment, I must say. Yes.
I'm not sure if that's good or bad news, really. I guess it's bad, isn't it, really?
It's bad news for our clients.
But it's good news for you guys anyway, so We're all in business, aren't we? We wanted to catch up with you, Deborah, because you've been around on the PR-wise. We picked up on a couple of press releases just recently about your knowledge and experience in the world of protecting assets in business, because this is something that upsets the balance quite regularly and can also be a big problem within a business, can't it?
Absolutely. And the impact of a divorce on a business can be substantial. So nowadays it's quite common for business partners to put into the agreements they have with each other to protect themselves basically before marrying.
There are some, I guess, as they always are in this kind of thing, but some high-profile cases of things that have gone wrong and have cost a fantastic amount of money. And it almost leaves you with a bit of a bitter taste and a feeling of it being a bit of a shame, really, because businesses can actually fold as a result.
That's not unusual, I'm afraid, but some simple steps before people marry can actually prevent that happening. There are ways that a person can protect themselves and minimise the impact of a business when or if they divorce.
Can you highlight some of those for us, please?
Yes, the most simplest way is to ensure that you keep the business and the business assets completely separate from the matrimonial assets. Now, sometimes that's easier said than done, but for example, don't use the income to pay off part of the mortgage or to meet other joint expenses. So keep the business in your sole name or the business assets completely separate from your spouse, and just don't mingle it with funds that they will have access to. Now, as I said, that is sometimes quite difficult to do depending upon the asset in question.
Yeah, I mean, these kind of feel like awkward conversations.
They're not the easiest, and we completely understand that, but they are a way of just checking that you and your spouse-to-be are on the same page before you marry. And couples shouldn't fudge any issue before they walk down the aisle. And this is one of them. It's just checking what they both believe would happen in the case of a future relationship breakdown.
Is part of the problem here, Deborah, that people just aren't proactive enough in having those conversations?
Yes, I think it's difficult because that kind of conversation needs to take place at a time when the couple are preparing for their wedding. So it's an otherwise very exciting time of their life, and they don't want anything to detract from that. But looking at every possible angle before you marry and what would happen in particular situations has to be a good idea. And it will save you an awful lot of money coming to talk to someone like me in future if the marriage breaks down.
So we've talked about assets. Is there anything else that can be done with assets?
Yes, you can place the assets in trust, and the beneficiaries of that trust might be, for example, your children or future generations. But it's important to bear in mind that there is a loss of control of those particular assets placed in trust, because the assets will be passed to the trustees and they will deal with the assets in accordance with the trust deed. So depending upon the asset in question, it may or may not be appropriate to place that particular asset in trust.
Yeah, these sound like quite complex procedures to go through. What are we talking about here, Deborah? Is this a really problematic procedure?
It's not. It really depends upon the value of the asset and the cost of, for example, setting up the trust and administering it. So we need to know more about that particular asset and, for example, whether it's going to be needed in future, in which case a trust simply wouldn't be appropriate because, as I said, there is a loss of control on that particular asset. So we need to weigh up the size of the asset in question, the value of it, and the cost of setting up and administering the trust.
Now, in the wonderful world of celebrity, we hear about partnerships and prenuptial agreements and things like this. I guess in a weird way, we're almost talking about a similar thing from a business perspective. Are we, or are we not?
We are, and business assets can be covered in a prenuptial agreement, and that's the third and most obvious option to protect oneself before marrying. Just to clarify, a prenuptial agreement is a legal agreement entered into by a couple before they marry or form a civil partnership, and that agreement seeks to determine the financial arrangements should the couple divorce in future, and it's intended to prevent a court giving its own financial outcome in those circumstances.
And Deborah, where does the law sit if you have nothing in place and you have a partnership, with your spouse and it all goes wrong and you split up? What happens?
In the absence of a prenuptial agreement, then it's matrimonial law that applies. And that law simply, or the law itself, there's a very wide discretion to reallocate assets from one party to the other, regardless of their origin or their legal ownership. So, for example, even assets, inheritances and family businesses, importantly, built up before the marriage are vulnerable to those court orders, and they could be, for example, a lump sum, maintenance by way of an income from the business that one party, typically the husband, is receiving. So that could be paid in maintenance to a wife and children. So there's not a case of one size fits all. There is a checklist of factors that the court has to apply when determining any financial orders that should be made upon divorce.
So I guess what you're saying is then that if ever you should be in a situation, for example, where you've done something that's not agreeable with the other half, and they turn around to you and say, well, I'm going to ruin you, that is actually possible.
Yes, that is impossible. The outcome in the absence of a prenuptial agreement will be determined by a judge if agreement cannot be reached between the parties and their respective lawyers. But there is a framework in place set out in statute that determines what happens. So threatening to take someone to the cleaners, very common, and that's heard a lot in the work that my team do. Yeah. But there is a framework in place to make sure that both parties obtain a reasonable settlement. Now, when parties think they haven't got a reasonable settlement, that's typically because the needs of the family have been prioritised. So, for example, if there are very few assets to share out in a divorce, but there are young children of the family, then the person who has those children living with them are going to get a much better deal because the children need to be housed. So it's all about meeting needs as a priority. And then once the needs of both parties and the children are met, then it's sharing out the rest in a fair way. And obviously what one party thinks is fair might not be fair to the other.
Sure, this must be quite a challenging environment for you because I guess in standard kind of law practices in business, it's all a little bit black and white. I guess if you, for example, you're owed money, there's a process that you can go through. But of course, with this process, you're also adding in the catalyst of emotion, aren't you?
Precisely. And a lot of what we do is taking the emotion out of a situation and seeing, the common sense of it. Typically when clients come to see me, the temperature is already sky high. So a lot of what we do is trying to bring that temperature down. And although a lot of people think that divorce lawyers are out there to really crank up the temperature, it's actually the exact opposite. There's a code of practice which we all abide by and which says that we have to bring the temperature down as much as possible. So we do send the parties off to talk to each other in a kind of mediation setting to try to reach agreement without incurring legal fees.
Well, Deborah, it's been really insightful to talk to you this morning. Many thanks for your time and thanks for coming on to share your knowledge with us as well. It is obviously one of those things that is going to require external assistance.
Yes.
And for the people that listen to the Business Hub, if they do wish to find out more information, where can we send them?
Seddons.co.uk is our website, and it has a lot of information on there about prenuptial and postnuptial agreements and the ways in which you can protect yourself both before marrying and actually after as well.
Okay, and you have a social media presence as well, do you?
We do, yes. Seddons Family on Twitter.
Okay, and on LinkedIn as well. We'll put a link from the Business Hub webpage to your LinkedIn profiles as well. But
thank you.
For the time being, Deborah, Jeff, many thanks for your time this morning.
My pleasure. Thank you.